The following program is made possible in part by the Dayton Bar Association.
Good evening and welcome to You in the Law. I'm Mike Monta, your producer and host for tonight's program. And our topic is going to be personal injury and laws accompanying that. Joining me as expert guests on our show tonight are Mr. James D. Brookshire of the firm of Dungan and Lefevre. Am I right on that?
That's correct.
And Mr. Brandon M. Allen, who is with Friend Friesen Arnold here in Dayton, Ohio. Tonight we're going to discuss things like negligence, liability, statutes, burdens, comparative negligence, and whatever will come up. Before we get to our discussion with our panel, let me remind you that You in the Law is a monthly presentation produced here at the studios of the Dayton Access Television. DATV comes to you on Time Warner Channel 5. It's the public access channel of Time Warner cable network here in Dayton. The program is also cablecast north and south on Channel 6, I believe. If you're watching Channel 6, you're seeing me. If you're not, then you aren't seeing me, I guess, but that's on Continental Cable Network through the auspices of the Miami Valley Cable Council. Executive producer for the program is former domestic relations judge Mike Brigner, and this is sponsored by the Dayton Bar Association. We'll talk a little bit more about them. Their director is Bill Wheeler, and we'll talk about some of their programs as we go along. As you saw before, this is a show is coming to you live, and it is an audience participation program. So the number which you'll see periodically, I hope more periodically than not, and there it is, 223-5311. If you have a question about personal injury law, please call in and you will get an answer from these gentlemen who know as much or more than anybody you know for sure, and most of the lawyers here in town. So we also stream live on datv.org, so you don't have to be watching us on TV. You could be watching us on your computer or your mobile phone somewhere. Again, if you have a call or a question, please call in. So let me turn to our panel now, and we're very fortunate to have these gentlemen with us. We'll first turn to Mr. Brandon Allen. Brandon, good to have you with us.
Good evening, Mike.
Tell us a little bit about your familiarity and background.
Well, thank you, Mike. I'm currently attorney, as you mentioned, at Friend Friesen Arnold here in Dayton. I've been practicing law for about 11 years here in the area. First 8 years of practice, I worked at a small general practice law firm in Oakwood, primarily doing insurance defense work, as well as some plaintiffs' personal injury work, wrongful death, probate, things of the like. The last 3 years I've been with Friend Friesen Arnold, primarily doing insurance defense work for personal injury cases, as well as probate and estate planning, trust work, and things like that as well.
Okay, thank you. Great to have you. And I turn now to Mr. James D. Brookshire, who I've known for years and years, and is an expert on plaintiff's law in this, if I'm not wrong.
Well, I don't know that anyone's an expert, Mike. I know that we do an awful lot of it in our firm. I've been practicing in this area of law for 24 years. I coincidentally also spent a couple of years at Friend Friesen Arnold, so I had the opportunity to see how the defense side of this type of litigation works. As far as my own practice, it involves, along with another attorney in our litigation section, it involves both auto accident and that type of personal injury work, as well as wrongful death cases, medical negligence cases, and a host of other areas of civil law where people find themselves injured through no fault of their own and in need of compensation for that while they recuperate, when they lose their earnings, when they have uninsured or underinsured coverage to address the instances where someone, say a motorist has no coverage, is driving without insurance, which unfortunately is way too common in this state. And we've been looking at these sort of cases for, well, I've been at Dungan and Lefevre for 13 years. Prior to that, as you know, I had my own shop. I shared space with some other attorneys in downtown Dayton.
I remember, and good to have you with us also.
Thank you.
Why don't we begin by telling our viewing audience what exactly is personal injury law, and it's basically people getting hurt and having to do something about it to become recompensed. I think there's more to it than that, obviously. So
There's a bit more.
tell us.
Well, first of all, this is different than workers' compensation, which is another very common area of the law where injuries occur. Those are in a workplace environment, and that's a separate and distinct area of the law, not one of the areas that we pursue. Essentially what we're talking about here is a person commits a negligent act, such as driving drunk, driving inattentively, or some other failure to behave reasonably, I guess would be the best way to put it. And as a direct and proximate result of that negligent act, they injure another person. The concept of negligence is basically founded on the idea that we all have a duty to each other in a society to behave reasonably. And negligence is essentially the failure to behave reasonably in a given set of circumstances. Now, in the auto context, that's often a matter of obeying the traffic laws. We all know that if you rear-end another vehicle, you're at fault for the accident. The simple fact that you rear-ended another vehicle doesn't give rise to a personal injury or negligence claim, however. The person you rear-ended has to actually have injuries that directly and proximately result from being rear-ended. The proximate result portion of that analysis is what we call the but-for test. But for you running into the back of my vehicle at 35 miles an hour, I wouldn't have this sprained neck and sprained back or broken arm or whatever the injuries happen to be.
All right, let me ask Brandon, because when you talked about your background, you also talked about insurance, and insurance is interwoven with the concepts of personal injury and how people might be made whole out of that.
In Ohio, we have what's called financial responsibility laws, which means that drivers of automobiles are required to have state minimum liability insurance policies in order to legally operate a vehicle on an Ohio roadway. Currently, Ohio has a $25,000 minimum policy that everybody is required to obtain and have to be a driver legally on a road in Ohio. Of course, it's possible, and you should, buy policy far in excess of the state minimum. From my perspective, every driver in Ohio should have at least a $100,000, $300,000 insurance policy to make sure that you're adequately protecting yourself and your loved ones if you cause an accident. So essentially how insurance works, Mike, is if I am negligent and I rear-end James when we're leaving the studio tonight, my insurance will compensate James to the extent that he is injured, up to including the limits of my policy. So in the example that I gave of $100,000 worth of liability coverage, if James has injuries that are in excess of $100,000, my insurance policy would pay him the first $100,000, and I personally would be responsible for any amount beyond that. That's again why I suggest to folks that the more insurance you buy for yourself, the better you're protecting yourself and your family and your assets that we all work hard for, so that you can compensate folks that you've injured as a result of your own negligence.
Now, just because you're covered up to $100,000 doesn't mean that the person that's injured gets that $100,000. I think you've already adequately explained that, but sometimes folks think, what is their liability? Do I get that?
Well, a common reaction in personal injury cases is folks that don't deal with this think it's an ATM machine. You get involved in an accident, it's worth a bunch of money, you're going to retire. That's not always the case. As James said, it's important that if you're involved in an accident, that in order to make a claim, you actually have to be injured. There's lots of people every day that are injured in accidents on I-75 and 70 throughout Dayton that get involved in car wrecks that are not injured, and those people don't have a legal claim under the law. If you
Let
are,
me stop you there just for a second. That doesn't mean they don't get their personal property damage for their car getting wrecked.
right, well,
It's two different things.
totally two different things. We're talking today about personal injury law, injuries sustained by an individual. Injuries to your automobile is a property damage issue, and that's a separate issue under your policy of insurance. So with respect to personal injuries, to actually have a claim that's worth monetary award or money from an insurance company, as James had mentioned, you have to be injured. And the way that lawyers typically calculate that is we'll look at somebody's medical bills. If you're injured and you go to the emergency room at Miami Valley Hospital, you're going to get medical bills from Miami Valley Hospital for the emergency room treatment, the emergency room doctor that saw you, radiologists, ambulance fee for whoever transported you there, and all those bills have a dollar value which you can associate with damages, and that would be an element which we would calculate in trying to arrive at somebody's damage level. It goes to say that the more bills and injuries you have, then the greater value your personal injury claim is. If you have substantial injuries or you're badly injured, multiple broken bones, broken leg, arm, things like that, that's going to be worth far more money in an average accident to somebody that has a small whiplash injury in a rear-end automobile accident at a red light.
Well, let's talk about a couple things. Just because you're in an accident, of course, doesn't mean you automatically get paid by someone. And I'd like you all to maybe discuss the issue of fault and maybe the comparison of fault, if there is any, and how that plays into somebody recovering before you get to the damage part of that.
Okay. What you're talking about is comparative negligence. And essentially what that means is that not only is one party responsible for causing the incident or the circumstances that led to the injuries that the other party is claiming. And it's the idea that not only do we all have a duty to behave responsibly towards the other members of our society, but we have a duty to behave responsibly ourselves. I like to use the example of a drunk driver. Drunk driver is by definition not a responsible party, and if that person happens to blast through intersection and they're involved in an accident, and there's suggestion that not only was the drunk driver at fault for blasting through the intersection, but also the party that they had the accident with in another vehicle. Say one of us is the drunk driver and the other one is running a red light simultaneously. All right, and those two collide. The question becomes, well, if the drunk driver had been sober, might they not have noticed that this person was getting ready to blast through a red light? Couldn't they have hit the brake, or might they have hit it sooner, or things of that nature? But the idea is essentially that if one or more people contribute to the cause of an accident, is the injured person entitled to recover? And essentially, if they're 51%, if they're 49% or less responsible, then they are legally entitled to recover.
In the clear.
Well,
sort of.
Sort of, yeah, because you have to take their degree of negligence into account still in calculating your damages.
Right.
All right. Disagreement there?
No, I would just add that even if that's the case, there's still a number of affirmative defenses which potentially could be raised, which would stop the ability of an injured plaintiff from being able to recover in a lawsuit. For instance, a medical emergency. If I'm driving home tonight and I have a heart attack and I go through a red light and I T-bone another car, the fact that I had a heart attack is going to bar the other driver from filing a personal injury claim against me because I had a medical emergency. If I have a vehicle that has no history of mechanical defects and I'm driving home and the front right wheel falls off, same sort of thing. So you have to analyze each situation based on the facts that were present, and people like James and I will look at the police report, we'll talk to witnesses, we'll talk to the clients about what happened in an accident, and we try to figure out, okay, well, are any of these affirmative defenses present, or is this a case of clear liability where the plaintiff is going to be entitled to something? The question is just a matter of how much. And you do all that sort of at the front end of a case when you're doing an initial evaluation, and then we go from there.
Okay, so basically we've been talking about, and I guess it's because it's the most common personal injury is through automobile accidents, but most of these principles would apply to other types of negligence or intentional torts. True?
Well, sure, absolutely. And again, the most common intentional tort that you see, intentional tort just means essentially that you're acting with thought and with will. It would be a fight situation. You and I are watching a sporting event at a bar. Your team scores a touchdown. I don't like it. I say some sort of smart aleck remark to you. You make a smart aleck remark back to me, and I punch you. Well, that's not negligence where I had an accidental injury and rear-ended you. I've intentionally done that. And the same sort of analysis would apply with respect to if there's any affirmative defenses. Were you injured? Do you have a claim for injuries? Things like that.
Okay, let's take a very short break here. We're about 20 minutes into the program. We are sponsored by the Dayton Bar Association, so we're going to talk a little bit about them. We're commercial free. We are live and in color, but we don't have commercials, so we'll tell you a little bit about our sponsor, or I'll tell you a little bit about them. We're represented by the Dayton Bar Association, which has been serving our community and profession for more than 125 years. And the exact date of the founding, I don't know who was there, but it was in 1883, and how many years is that? More than we can count, 133, almost. So, the bar provides a variety of community services for the benefit of our citizens, including, but not limited to, a lawyer referral service. If you don't have a lawyer, let's say you do have a personal injury, and we'll probably talk about that a little bit later. You say, well, who's good at getting me a lot of money for my injury? And you don't know, and your friends don't know. You could call the Bar Association at 222-6102, and they will refer you to a person specializing in personal injury law. If you need to be a notary, want to notarize people's documents, or a company you're working for requires you, there is a notary public service with application and testing, and I know that they do that because I was on the committee once, and the people actually have to take a test to do it and learn things about being a notary. So. One of the most important things we have is called a Wills for Heroes program, where volunteer members of our association create wills for emergency first responders, firefighters, police, and EMTs. A very valuable program. If you fall into those categories, call the Bar Association, and the number to call is 222-7902. And they'll tell you when the next time this program is available, usually on a Saturday at some civic building. We have a website of www.daybar.org, where there's reference information, guide to services. We have a volunteer lawyers project. I'm about telling you about everything there is to know here, where serving the disadvantaged and founded and supported by the Dayton Bar Association, people that cannot absolutely hire a lawyer, they can help with that. So, as I said before, Bill Wheeler is the executive director, has been doing a fine job for most of this century. When did Bill start, do you know?
I'm not sure.
10 years ago,
It's been quite a long
something
time.
like that. But a very capable gentleman running our bar association. So again, you are watching You and the Law, if you didn't get it from that last thing. And we're talking about personal injury tonight. We have two personal injury attorneys, Mr. James Brookshire, who works for Dungan and Lefevre in Troy, Ohio. Do they have offices down here, or is it?
No, we don't have a Dayton office, but we also have a Piqua office.
Piqua, okay. I don't know if we get to Piqua, but, and Mr. Brandon Allen, who works for Friend Friesen Arnold in downtown Dayton. What's your building located at?
It's the
Brandon?
Fifth Third Center,
Fifth Third Center, and that's right on the corner of Main and Third, as I
right across
recall.
from the old courthouse.
So if you have any questions, our number here for our live call-in is 223-5311. If you haven't called, be the first to call us. So, not that we can, there it is right there. And we're live February 1st. Tomorrow's Groundhog Day and voting day in other places somewhere tomorrow. Let me pose like a hypothetical. Somebody's had a traffic accident. They have been injured. Maybe they don't know it right away, but they take them to the hospital and things develop. They might be, after an exchange of information, they might be contacted by the other person's insurance company, might be contacted by their, or they would contact their own. What steps should that person take to rectify his problem and seek damages for whatever his claim might be?
Well, from the perspective of the attorney who represents the injured victims, some of the things that I advise people to do are things they shouldn't do initially. All right. Number one, they shouldn't be privately interviewed in a recorded interview over a telephone by the representative of the insurance carrier for the responsible driver.
In other words, don't talk about it without having some sort of counseling. Counsel, not counseling.
Yeah, absolutely.
Right.
And the reason that I suggest that is that these can become, as Brandon alluded with comparative negligence defenses and things of that nature, these can become very complicated fact patterns. And before a person has an opportunity to fully evaluate things like a crash report and the testimony or the recollections of witnesses, they shouldn't be asked to commit to a particular story that may or may not be wholly accurate about what occurred in what is essentially a traumatic event. So
most people are pretty shook up.
Absolutely.
Whether they're at fault or whether they're the person who is damaged.
Exactly.
Okay.
And that's not the greatest environment in which to garner all of the facts that are genuinely accurate and true about what occurred to cause the incident from which they were injured. Plus, if they've been to the emergency room, it's likely that they've been given some kind of painkiller. And if they're taking their prescription as ordered by a physician, it's also likely that they're not going to have the best recollections while they're under the influence of pain medication. So my advice to people, and perhaps it seems a little self-serving given what I do for a living, is my advice to people is get an attorney early. It's our job to help you organize those facts, and it's our job to collect all of the relevant facts and to evaluate the situation from ground zero.
Okay. Now, I, in talking about the Bar Association, of course, gave out a number for locating a lawyer. What suggestions would you have to a person who competently looking for an attorney to represent them, and should they go with the first person who they talk to, or how should they evaluate, do you think?
Well, I think it's like many other things. I mean, choosing a lawyer can be one of the most important decisions in your life if you have a serious situation that is causing a great deal of damage, not only to your body, but to your financial well-being, to your family. And I'd suggest that you don't necessarily choose the first person that sends you a letter, or that you get on the phone, that you take some time to ask them important questions. Is this what you do for a living, or is this just one part of your practice? How long have you been doing this? My practice extends far outside the Miami Valley, but that's not necessarily true for everyone. You certainly want to find out what the attorney you're talking to, what they do, as a general or a majority of their practice. I think there are some very fine lawyers who also have some other general areas that they pursue. But my recommendation is that you speak with someone, or you continue to speak to people until you find someone who this is what they do as the majority of their practice, day in, day out.
I think a lot of times if you watch TV or TV programs or advertising maybe, that a person might get the idea they have to do something kind of fast in order to recover. And I want to ask you about what's called statutes of limitation and how they apply to claims for personal injuries in Ohio here.
Is that directed to
Oh,
me or
either
to
one
both
of
us?
you.
Okay.
Well, Mike, in Ohio, we have a 2-year statute of limitations for an injured party to file a lawsuit. So essentially that means is you get in an accident on January 1st of 2016, you have until January 1st of 2018 in which to file a lawsuit. And if you file it on January 2nd of 2018, it's too late. So you can try to resolve the case with your lawyer, negotiate with the insurance company, reach a settlement resolution that you and your attorney are happy with up until the point in time where you have to file a lawsuit. And if you don't file it, then you've lost your right to do so.
Regardless of the merits of your claim.
Right.
Okay. Now, in your discussion just now, you indicated talking with your lawyer and perhaps insurance companies. Everybody doesn't have to file a lawsuit then in order to recover.
Well, it's almost always advisable and it's almost always easier to try to settle something with what we call pre-suit. Before you initiate litigation, which involves a bunch of lawyers, a bunch of time, a bunch of money, court dockets, delays, things like that, lawyers like James and I put together settlement demand packages listing out what an injury claim is, how this has affected somebody's life, what the changes to them have been as a result of this accident. We would describe the liability, why it's clear in this case, and then we would send that stuff off to an insurance company if I'm representing a plaintiff and suggest that this case is worth X number of dollars, make us an offer to resolve it. And oftentimes cases get resolved before the need to file a lawsuit, and that's generally the best for all parties involved. The insurance company doesn't have to retain lawyers to defend the case, although in my position that hurts somebody like me because I defend those sorts of cases. And the compensation is done, get to the injured party quicker. If you file a lawsuit, things are generally going to slow down. Lawyers get involved, they ask for documents, they exchange information, and things generally go slower than if you resolve it before a lawsuit is filed.
Okay. Our floor director tells us we have a caller, and we would request your question if you are on the line. Good evening.
I am, in fact, on the line. Thank you for taking my call. It's actually a two-part question, and I'll ask the first part, and then if I can ask the second part after, that would be appreciated. So the first part of the question is, when we had that big snowstorm a couple weeks ago, I noticed that there were some tire tracks that somebody presumably lost control in my neighborhood and drove up onto our front lawn. Not really far, but just enough that they probably had to back off the curb. Well, as the snow melted, I noticed that they had hit a sewer vent, which was on the corner of the curb, and it actually pushed the sewer vent into our yard. Basically knocked it off, broke it from its placement. So I'm wondering, as a homeowner on whose property this sewer grate exists, if there were damages to the car or to the occupants of the car, am I held liable for that?
All right, that's part one. Did you all get that question?
I think so, Mike. And my initial response would be maybe. Lawyers like to hedge and say that, well, it depends on what happens. In that circumstance, the answer is probably not. Probably not liable if your house does not, and your yard does not have anything that would be considered to be dangerous or some sort of defect in the property that could cause general harm to the public, and this person happened to drive onto your lawn and hit it and therefore caused injuries to themselves, then you probably do not have any liability. On the other hand, if you were to have some sort of sinkhole or something like that in your yard that you hadn't adequately covered or marked and give warning to people, and somebody fell in that, then yes, you could be liable as a homeowner for somebody's personal injuries in that circumstance.
I sort of got inferentially in that question, maybe the snow covered up potential damages. Would that make a difference? If the person lost control of themselves, maybe there was some defect on the property, hit it but didn't see it, or would that make a difference?
I'd suggest no. Again, we're talking about the operation of a motor vehicle and a duty to behave reasonably.
Right.
We know it's slippery when you drive in the snow, and you know that you need to stay off the gas pedal and take a bit more time and a bit more care as you're traveling down a snowy road. The fact that this person lost control or failed to maintain their lane, if you will, and came into your yard, sir, I would suggest that that's pretty much a complete defense to any injury or damage that they might claim as a result of encountering something in your yard under your snow.
Does that answer your question?
It does. And that actually leads me to my second question, which is, as I wait for the city to come and fix it, if someone were to fall into that, maybe while walking this evening, or hit it in their bike or something, am I held liable for that now that it's essentially a defective, unprotected sewer?
You mean based upon the car hitting it and making it defective?
Correct. So
okay.
Basically, what it is it's a coverless sewer. The manhole is off of it. And I'm wondering if someone were to just be taking a walk or on a jog and they decide they want to cut through that curb and ended up falling and hurting themselves, as a homeowner, am I liable for that injury?
Sir, are you talking about a municipal sewer?
Yes.
It's on his property, I think he said, though.
All right, well, I live in the city of Dayton and we have a sewer right at the corner of our lot, and it's on the tree lawn. As far as I know, that's maintenance and repair is the responsibility of the municipality. If it were me, though, just as a matter of basic courtesy to my neighbors and a little bit of self-protection, I might go and find some of that cheap yellow tape you can buy at a hardware store and drive a few stakes in the ground and circle that thing with the yellow tape, to prevent someone from accidentally running into or walking into a situation like that, regardless of whether or not you could be held
Well,
personally
the homeowner
responsible.
should probably contact the municipality.
Absolutely.
They
Absolutely.
just don't know
Absolutely.
it on their own.
Right.
Yeah,
Yeah.
we all have an obligation and a duty to protect ourselves. And to the extent that you have the ability to do that, get a piece of plywood, put it over the hole so nobody can fall in it, and then as James suggested, mark it off so people know that, then you've done everything you possibly can do after you call the municipality and say, hey, this is broken, please come fix it. At that point in time, if you've done all those things, then it's not possible for anybody to allege that you've done something wrong and not protected yourself.
All right. Does that answer part 2?
It does. I guess I've got a trip to the hardware store now.
Okay.
All right.
Thanks for your call.
Thank you.
All right. When we were talking about possibly resolving some of these cases before having to file a lawsuit within your 2 years, I guess, it occurred to me that other than just talking to your lawyer and insurance representative, you possibly might get into some sort of other techniques, which might be mediation or arbitration. Is that available before filing? And how does it work?
Well, mediation certainly is available pre-suit. And unless you're involved in a situation with a contract that requires a mediation or an arbitration, that's a voluntary activity between the parties. Arbitrations, at least in my experience, have tended, though we see fewer of them now, in the personal injury realm anyway, have tended to be things that were organized by our courts as a less formal mechanism for potentially resolving a case prior to trial, but also after a lawsuit has been filed. But mediations are an increasing tool that we use to resolve cases, again, fairly and expeditiously, without all of the complications and expense and delays that can be occasioned by filing a lawsuit and following that process all the way through to a jury trial.
The Ohio Supreme Court keeps statistics regarding every civil case that's filed in the state of Ohio on a yearly basis. And according to the Ohio Supreme Court statistics, 98 to 99% of all cases are resolved before a jury trial. So that means that the vast majority of these cases are settled in these alternative dispute resolution mechanisms, like a mediation, very infrequently now would be an arbitration, but that's certainly the trend that courts have gone to and that practitioners in these areas have gone to, because it gets the job done. And if both sides can walk away not necessarily happy with the result, but content that they've resolved it, then people can think, we've done okay and let's move on with our lives. And it's a good mechanism and tool to not have to incur the expense and time of litigation going through trial.
Do you think that's the main reason that the case is settled before having trial? Or do people get cold feet, or do they realize they're asking for too much, or maybe the insurance company representing the defendant starts out in too harsh a position, or what? Maybe you answered that in the way you phrased it, that everybody kind of sees the other person's point of view after a while.
Well, I think for all the reasons you just mentioned. Some people don't want to have the public display of a trial. Some people don't want to have to endure listening to testimony about bad things that have happened to their spouse or them. There is a cost component. Lawsuits cost money. If you have to hire doctors to come testify, that could be a substantial expense for both plaintiffs and defendants. Most people have come to the idea that if we can use that money towards resolution of the claim, and that makes sense within the parameters that we're working with on trying to reach a settlement, then it's better to use that sort of money to resolve the claim than to pay an expert to have a trial with. Then you have an assured result that we can reach, and juries are unpredictable. Sometimes you can do really well, and sometimes you can get zero from a plaintiff's perspective. From a defense perspective, of course, you always hope for zero, but sometimes you can get hit hard. It just really depends on the makeup of the jury and what happens in that particular case.
Well, James, when somebody comes in with their case, let's assume for the purposes of our discussion here, that it's been determined that the other person's at fault, and you're trying to measure and assess the value of the claim. What advice are you going to be giving to people of things to do, other than, everybody feels bad after they, break their arm or get a concussion or something like that? What are you going to employ them to do, not employ, but have them do to further their own claim that you can evaluate and take it forward?
Well, my first instruction to every client is do exactly what your physicians say. If you've been prescribed medication, there's a reason your doctor gave you that. It's for your benefit. Take it. If the particular medication doesn't sit well with you, go back to your doctor and they can fine-tune that either by dosage or with some other form of medication. If you're prescribed physical therapy, for instance, make all of your appointments. No excuses. All of those things are designed to improve upon the state of your injuries and to foster the healing process. So that is always job one. Do what your doctors say, do it the way they say it, listen to them, and do your best to get better. One of the things that the law requires is that an injured person do what we call mitigating their damages. In other words, they can't make their situation worse. And if they refuse to follow medical advice or they fail to follow through with medical advice or medical procedures, they are in essence making their own situation worse. And in a fair system, the responsible party shouldn't have to pay for more than they actually caused. By the same token, there are often instances where someone my age or beyond has a bit of arthritis.
Late 40s, early 50s, is that what
we're talking? Late 50s, early 60s
okay.
here.
All right.
And say you've got a little bit of arthritis already developed.
I don't want anybody to call in and make a mistake or anything.
No. Okay. They have what we call pre-existing condition. Which insurance companies love pre-existing conditions for a lot of reasons, because they try to get out from under claims by alluding that virtually everything
Spoken
my
like
client
a true plaintiff's lawyer.
Absolutely, and 24 years of experience to boot. Essentially what a pre-existing condition is anybody who's walked under gravity for as long as I have, standing straight up, has degenerative disc disease is what doctors refer to it in their cervical, thoracic, and lumbar spine.
You're wearing down.
Absolutely.
Yeah.
Right. So as a result, when I get rear-ended at 35 miles an hour, my neck, my back, and my low back are more fragile than, say, a 20-year-old's would be. And I'm going to be injured more seriously as a result of that. All right. That changes the dynamic on what a physician will prescribe, both in terms of physical therapy, because I'm not as tough as a 20-year-old, and also in terms of the medications and muscle relaxers and other things that I might be prescribed to deal with that. I have a duty to do all of the things that doctor told me to do, and to take the medications they told me to take. If I fail to do that, I've weakened my case. I have, in fact, failed to mitigate my damages, and I have, as a result of my own failure to behave reasonably again, arrived at a situation where I'm deservedly going to get less money from a jury or from a settlement than I would have if I had done all of the things I was supposed to do.
And I would just add to James's point that from a defense perspective, when I am looking at somebody's medical records and I see that their doc sent them to physical therapy to work on a back injury, and we have 3 or 4 visits in a row where they no-showed or they called in and said they weren't going to be able to make it, then it seems a reasonable inference is they're not trying to get themselves better. And to James's point, if you're not trying to get yourself better, then you're not doing everything you can to help yourself, and your case is therefore worth less money. It's very important that people follow their doctor's advice and follow through on the treatment they've been given in an effort to recover themselves and make themselves better.
Let me ask you this, representing defendants and insurance companies who also represent the defendant in the cases, generally you're not in the case until either just before filing of the lawsuit or filing the lawsuit. Am I correct on that?
That's
The
accurate.
adjuster of the insurance company is pretty much running the show before that. When you either hear that the case is being filed or has been filed and you're notified, what is it that the defendant and the insurance company is wanting you to do, and how do you go about doing that?
Well, in Ohio, the rules that courts are governed by are called the rules of civil procedure. And when an injured person files a lawsuit, it's called a complaint. It's extremely important, and it happens all the time, that if you get paperwork from a court, you call your lawyer, you call your insurance company, you say, hey, I've got this stuff from a court, looks like I might have been sued. Because you have to file what's called an answer within 28 days of receiving that paperwork from the courthouse. And what it will be is a summons and a complaint saying that you are hereby notified, you have been named as a defendant in the lawsuit, captioned the name of the plaintiff versus you, and you have an obligation to file that answer to preserve your rights to all the defenses we talked about before within 28 days of receiving that paperwork. And if you do not, then the plaintiff can take a judgment against you against your will.
Okay, let's say that doesn't happen. Let's say they get over to you in due time. You file an answer. Most of the answers are pretty much the same to start with until a discovery process starts. What do you do from there?
Well, the first thing we would always do, if James and I are on the opposite sides of the case, like we've been many times in the past, is I would file an answer and I would send him paperwork, what we call discovery, asking his client to answer questions and asking for documents. Do you have photographs of the accident? Do you have photographs of your injuries? Do you have any recorded statements from anybody at the accident scene? Do you have medical bills? I want to have authorizations to be able to gather your medical records from your doctors so I can look at them and verify them on my own. His client would then answer the questions, sign them, the documents, send them back to me, and that's how we do case evaluation. James would have the ability to do the same thing to my client, send them questions that he or she would be required to answer in discovery.
Okay.
What were you doing before the accident? Why were you doing that? Where were you going? How fast were you going? Things like that. And then we take that information and we evaluate it as part of the determination to see what a case is worth. If there are any viable defenses, are there not any viable defenses? And at that point in time, we have a lot better understanding of what the case is about than when we initially started with the complaint being filed and then the answer being filed.
Okay, so part of your duty to your party, the defendant and the insurance company, is to find out everything you can about it and at least assess the actual damages to the case, the damages the person have incurred, and of course James has done the same thing before you even get the case probably. But there's some wild cards in determining the worth of the case. Would you both agree to that? I mean,
absolutely. So lost wages, for instance, is always a big unknown in personal injury cases. If you miss work as a result of a personal injury and you lost money as a result of missing work, you can be entitled to compensation for that money you lost. Well, every lost wage claim is not the same. Mm-hmm. If I am self-employed as a contractor, let's say installing drywall, and I am unable to work for 3 weeks because my back hurts because I got hurt in this accident, that's different than somebody that has an hourly position working at a factory where we had guaranteed employment for 40 hours a week with mandatory 10 hours of overtime where they would have received time and a half and things like that. The drywall installer, in my example, would have what I would call speculative employment. Mm-hmm. And the law does not compensate people for speculative evidence. You have to have definitive proof that but for this accident, you would have had these jobs and you lost out on this money and things like that. So that's absolutely a wild card that you have to factor into personal injury cases. And frankly, some lost wage claims can be significant. You could have somebody that missed $40, $50, $60,000 worth of work that dramatically changes the value of the case. That would be something that James and I would analyze early in the case.
Very briefly, and I say briefly because we're almost at the end of our hour, but how does pain and suffering get into the evaluation of these cases? And I guess the plaintiff tries to find out first, and then the defendant says, maybe not.
Well, that is obviously the most subjective component of a claim. We all hurt differently. We all have different pain thresholds and things of that nature. While we've been talking here about alternative means of resolving cases the overwhelming majority of how these files end up ending or settlements are arrived at, it's one of the areas where I think I appreciate juries most. And it's one thing I've learned in 24 years is, as a general rule, juries get it right. And if a person talks to them about how they hurt and how long it hurt and the ways that it affected them, it affected their sleep, it affected their ability to do basic household tasks, things of that nature. A person who'd get up on a witness stand in a case like that and relate those things honestly, it's going to ring true with jurors who have had similar experiences. Unfortunately, when you talk about settling cases without a jury arriving at a determination of those sort of damages, you have to rely upon my impression of my client versus Brandon's impression of my client, per se, or an insurance adjuster's impression of them. But it's the hardest portion of the claim to prove in some respects. But I think ultimately, and I miss jury trials, we don't do enough of them. I think it's the part where the jury gets it right more often than not. Because it is a common experience, and that's what our jurors are for.
That makes it a little harder to resolve them, going back to Brandon's example of the Supreme Court saying most of these cases are resolved before a jury trial and before maybe the anguish for both sides. Are the parties capable in general of assessing that component, do you think?
Well, I think so. I mean, part of the initial evaluation that you do when you would send off a settlement demand package from a plaintiff's perspective, as I said, is you're going to describe the pain and suffering that your client endured. There is a significant difference in a burn injury or an open compound fracture injury versus a soft tissue injury from a whiplash. It hurts different, the residual pain is different sort of treatment, remedies, things like that. And I think that for the most part, people that practice in this area of law understand that, they get that, you can assign different values to that. Certainly, I agree with James's point that for the most part, juries get those things right, and it's difficult in some regards to convey that in a letter or demand package to an insurance company because you're not seeing people talk live in open court like you would in a jury trial. But I do think that you can convey that message if you're doing a good job, back to James's point of how you pick your lawyer. If the lawyer does a good job of conveying that message, I think people can get it.
Okay. We have about 2.5 minutes here. Are there any recent developments, I'm only going to give you a minute or a minute and a half here, that are sending the personal injury law one way or the other as far as righting the wrongs that happen when people get injured?
I don't know that I would call it a recent development in Ohio now, because we've been burdened with these statutes for quite a number of years now. But in the early 2000s, our legislature and our governor at the time enacted what has been referred to as tort reform. Ladies and gentlemen, there's no reform going on at all, in my view. What's happening is that the civil justice system is being watered down, and decent, hardworking, completely innocent victims are being denied their full measure of justice, in my view, under these laws. And that is certainly having an impact upon personal injury litigation. Essentially, I think what's happened is that in addition to the already large expenses that exist for my clients in putting together a case before they prepare it to present it to a jury, they're now confronted with the concept that even though they prove larger damages to a jury, they're stuck with a cap, except in very rare circumstances. So in essence, and this directly applies to your question about pain and suffering damages, in essence, our tort reform statutes have put a maximum price tag on the value of a human life. What that's resulted in for me is advising my clients perhaps more often to settle for an amount that I would never have found acceptable prior to these caps on damages because of the genuine suffering that they're experiencing. But under the current regimen of the law, is really their only way to go.
Okay. I'm going to have to cut you off. We're down to our last little bit. Our hour went by pretty fast. You've been watching You and the Law. We've been talking about personal injury with our two expert guests, Mr. James Brookshire and Mr. Brandon Allen. Hope you've enjoyed the show. I want to thank all the volunteers behind the scenes who have made this program possible. I want to say a shout out to Katie and Lily. Hope you're watching and enjoying the show. And my daughter's birthday is today, February 1st. I won't say how old she is. There it is, right on the screen. So I've been your producer and host. I'm Mike Monta. Thank you for joining us. We'll see you again next time. Good night.